Welcome to literary and jury charge practice. Let's start out with jury charge. Ready? Here we go. Ladies and gentlemen of the jury, this case is submitted to you by asking questions about the facts which you must decide from the evidence you have heard in this trial. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. But in matters of law, you must be governed by the instructions in this charge. In discharging your responsibility on this jury, you will observe all the instructions which have previously been given you. I shall now give you additional instructions which you should carefully and strictly follow during your deliberations. 1. Do not let bias, prejudice, or sympathy play any part in your deliberations. 2. In arriving at your answers, consider only the evidence introduced here under oath and such exhibits, if any, have been introduced for your consideration under the rulings of the court, that is, what you have seen and heard in this courtroom, together with the laws given to you by the court. In your deliberations, you will not consider or discuss anything that is not represented by the evidence in this case. 3. Since every answer that is required by the charge is important, no juror should state or consider that any required answer is not important. 4. You must not decide who you think should win and then try to answer the questions accordingly. Simply answer the questions and do not discuss nor concern yourselves with the effect of your answers. 5. You will not decide the answer to a question by lot or by drawing straws or by any other method of chance. Do not return a quotient verdict. A quotient verdict means the jurors agree to abide by the result to be reached by adding together each juror's figures and dividing by the number of jurors to get an average. Do not do any trading on your answers. That is, one juror should not agree to answer a certain question one way if others will agree to answer another question another way. 6. Unless otherwise instructed, you may answer a question upon the vote of 10 or more jurors. If you answer more than one question upon the vote of 10 or more jurors, the same group of at least 10 of you must agree upon the answers to each of those questions. These instructions are given you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and the judge. If it should be found that you have disregarded any of these instructions, it will be jury misconduct, and it may require another trial by another jury. Then all of our time will have been wasted. The presiding juror or any other who observes a violation of the court's instructions shall immediately warn the one who is violating the same and caution the juror not to do so again. 1. Negligence means failure to use ordinary care, that is, failing to do that which a person of ordinary prudence would have done under the same or similar circumstances, or doing that which a person of ordinary prudence would not have done under the same or similar circumstances. 2. Ordinary care means that degree of care that would be used by a person of ordinary prudence under the same or similar circumstances. 3. Proximate cause means that cause which, in a natural and continuous sequence, produces an event and without which cause such event would not have occurred. In order to be a proximate cause, the act or omission complained of must be such that a person using ordinary care would have foreseen that the event or some similar event might reasonably result therefrom. There may be more than one proximate cause of an event. Intentional infliction of emotional distress occurs when the defendant acts intentionally or recklessly with extreme and outrageous conduct to cause the plaintiff emotional distress, and the emotional distress suffered by the plaintiff was severe. Extreme and outrageous conduct occurs only when the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. A person commits an assault if he 1. Intentionally, knowingly, or recklessly causes bodily injury to another, or 2. Intentionally or knowingly threatens another with imminent bodily injury, or 3. Intentionally or knowingly causes physical contact with another when he knows or should reasonably believe that the other will regard the contact as offensive or provocative. False means that the impression created, if any, is not literally true or not substantially true. An impression is not substantially true if in the mind of the average person the gist of the impression is more damaging to the person affected by it than a literally true impression would have been. Defamatory means that an ordinary person would be left with an impression that tends to injure a living person's reputation and thereby expose the person to public hatred, contempt, or ridicule, or financial injury, or to impeach the person's honesty, integrity, virtue, or reputation. You are instructed that any monetary recovery for past or present for loss of earnings, loss of earning capacity is subject to federal income taxes. Any recovery for past, present mental anguish, past, present injury to character, and nominal damages regarding defamation is not subject to federal income taxes. Exemplary damages means any damages awarded as a penalty or by way of punishment, but not for compensatory purposes. Exemplary damages include punitive damages. Factors to consider in awarding exemplary damages, if any, are A, the nature of the wrong, B, the character of the conduct involved, C, the degree of culpability of the wrongdoer, D, the situation and sensibilities of the parties concerned, E, the extent to which such conduct offends a public sense of justice and propriety, F, the net worth of Andrew R. Dick, aka Andy Dick. Negligence means failure to use ordinary care, that is, failing to do that which a person of ordinary prudence would have done under the same or similar circumstances, or doing that which a person of ordinary prudence would not have done under the same or similar circumstances. With respect to the condition of the premises, Tree 50 Group, LLC, aka DBA Trees, was negligent if 1. Andrew R. Dick, aka Andy Dick, posed an unreasonable risk of harm, and 2. Tree 50 Group, LLC, aka DBA Trees, knew or reasonably should have known of the danger, and 3. Tree 50 Group, LLC, aka DBA Trees, failed to exercise ordinary care to protect Robert Tucker from the danger by both failing to adequately warn Robert Tucker of Andrew R. Dick, aka Andy Dick. Ordinary care, when used with respect to the conduct of Tree 50 Group, LLC, aka DBA Trees, as an owner or occupier of a premises, means that degree of care that would be used by an owner or occupier of ordinary prudence under the same or similar circumstances. Ordinary care means the degree of care that would be used by a person of ordinary prudence under the same or similar circumstances. Proximate cause means a cause that was a substantial factor in bringing about an occurrence or injury, and without which such occurrence or injury would not have occurred. In order to be a proximate cause, the act or omission complained of must be such that a person using ordinary care would have foreseen that the occurrence or injury or some similar occurrence or injury might reasonably result therefrom. There may be more than one proximate cause of an occurrence or injury. After you retire to the jury room, you will select your own presiding juror. The first thing the presiding juror will do is to have the complete charge read aloud, and then you will deliberate upon your answers to the questions asked. It is the duty of the presiding juror, 1, to preside during your deliberations, 2, to see that your deliberations are conducted in an orderly manner and in accordance with the instructions in this charge, 3, to write out and hand to the bailiff any communications concerning the case that you desire to have delivered to the judge, 4, to vote on the questions, 5, to write your answers to the questions in the spaces provided, and 6, to certify to your verdict in the space provided for the presiding juror's signature, or to obtain the signatures of all the jurors who agree with the verdict. If your verdict is less than unanimous, you should not discuss the case with anyone, not even with other members of the jury, unless all of you are present and assembled in the jury room. Should anyone attempt to talk to you about the case before the verdict is returned, whether at the courthouse, at your home, or elsewhere, please inform the judge of this fact. When you have answered all the questions you are required to answer under the instructions of the judge, and your presiding juror has placed your answers in the spaces provided and signed the verdict as presiding juror, or obtained the signatures, you will inform the bailiff at the door of the jury room that you have reached a verdict, and then you will return into court with your verdict. Okay, let's see. Try some literary material. This is called Shaking Things Up. We dispel 3 common myths about earthquake insurance. Ready? Here we go. When the Great Shakeout takes place October 19, you might participate in a safety drill at work or at school. You might even be inspired to come up with an evacuation plan for your family at home or invest in an emergency supply kit. But will you think about how you might rebuild your home after an earthquake? If you're like most Californians, your answer is probably no. According to the California Earthquake Authority, CEA, the not-for-profit earthquake insurance provider that writes more than 75% of the residential earthquake policies in the state, only about 10% of Californians with homeowners insurance also have an earthquake policy. What's holding them back? Well, it's certainly not doubt about the probability of an earthquake. The U.S. Geological Survey's most recent forecast put the chance of a trembler with a magnitude of 6.7 or larger hitting California sometime in the next 30 years at 99%. More likely, it's misconceptions about earthquake insurance. Here are some common myths and the truth behind them. I don't need it because my homeowner's insurance will cover the damage. This might be the biggest misconception about what happens after an earthquake. A separate earthquake policy is the only thing that will cover damage to your home caused by a trembler. Damage caused by shaking from an earthquake is totally excluded in all homeowners insurance policies. An exception is damage caused by fire after an earthquake. Don't count on the federal government to step in. The Federal Emergency Management Agency can provide disaster assistance with low interest loans, but they typically don't provide enough money to allow you to rebuild your home. It's so expensive and the deductibles are so high that I can't really afford it. If you haven't looked at an earthquake policy in a while, you might be pleasantly surprised. At the beginning of 2016, the CEA dropped rates an average of 10% and rolled out a range of new deductible choices between 5 and 25%. What's more, policies are more flexible now. All homeowners or mobile home coverage includes the cost of making emergency repairs, rebuilding or repairing your home, and bringing your home up to the current building codes when making covered repairs after an earthquake. Beyond that, you may opt to cover damage to your personal belongings and loss of use, the cost of living elsewhere if after an earthquake. The premium calculator on the CEA's website, earthquakeauthority.com, can help you figure out what types of coverage you need along with the estimated cost. It doesn't even come close to covering everything I need, so it's not worth it for me. Again, if you haven't looked into a policy for a few years, you might find that things have changed for the better recently. For instance, the CEA increased limits on personal property and loss of use, so you can now get $200,000 worth of coverage for the former and $100,000 for the latter. In addition, the CEA now offers optional coverage for breakables like dishes or ceramics and masonry veneer, decorative brick or stone on the exterior of your house, higher limits for chimney repair, and coverage for energy efficiency and environmental safety upgrades. Get back to some jury charge. Ready? Here we go. Members of the jury, now that you have heard all of the evidence and the arguments of counsel, it becomes my duty to give you the instructions of the court concerning the law applicable to this case. It is your duty as jurors to follow the law as I shall state it to you. and to apply that law to the facts as you find them from the evidence in the case. You are not to single out one instruction alone as stating the law, but must consider the instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law stated by me. Regardless of any opinion you may have as to what the law is or ought to be, it would be a violation of your sworn duty to base a verdict upon any view of the law other than that given in the instructions of the court. It would also be a violation of your sworn duty as judges of the facts to base a verdict upon anything other than the evidence in the case. In deciding the facts of this case, you must not be swayed by bias or prejudice as to any party. Our legal system does not permit jurors to be influenced by prejudice or sympathy or public opinion. Both the parties and the public expect that you will carefully and impartially consider all the evidence in the case, follow the law as stated by the court, and reach a just verdict regardless of the consequences. One of the parties in this case, Eisenhower Road Flea Market Inc., is a corporation. Another, Louis Vuitton Melee, is a business entity organized under the laws of France and bearing some resemblance to a corporation or limited liability company. Corporations and other business entities of this type are entitled to the same fair trial at your hands as is a natural person. The law is no respecter of persons, and all persons, including these organizations, stand equal under the law and are to be dealt with as equals in a court of justice. When a corporation or similar business entity is involved, of course, it may act only through natural persons as its agents or employees. In general, any agent or employee of a company may bind the company by his acts and declarations made while acting within the scope of the authority delegated to him or within the scope of his duties as an employee of the company. Of course, the agent or employee may continue to be personally liable for the consequences of his or her own acts or omissions. As stated earlier, it is your duty to determine the facts, and in so doing, you must consider only the evidence I have admitted in the case. The term evidence includes the sworn testimony of the witnesses and the exhibits admitted in the record. Remember that any statements, objections, or arguments made by the lawyers are not evidence in the case. The function of the lawyers is to point out those things that are most significant or most helpful to their side of the case, and in so doing to call your attention to certain facts or inferences that might otherwise escape your notice. In the final analysis, however, it is your own recollection and interpretation of the evidence that controls in the case. What the lawyers say is not binding upon you. So, while you should consider only the evidence in the case, you are permitted to draw such reasonable inferences from the evidence as you feel are justified in the light of common experience. In other words, you may make deductions and reach conclusions which reason and common sense lead you to draw from the facts which have been established by the testimony and exhibits in the case. There are, generally speaking, two types of evidence from which a jury may properly find the truth as to the facts of the case. One is direct evidence, such as the testimony of an eyewitness. The other is indirect or circumstantial evidence, the proof of a chain of circumstances pointing to the existence or non-existence of certain facts. As a general rule, the law makes no distinction between direct and circumstantial evidence, but simply requires that the jury find the facts in accordance with the preponderance of all evidence in the case, both direct and circumstantial. Now, I have said that you must consider all of the evidence. This does not mean, however, that you must accept all of the evidence as true or accurate. You are the sole judges of the credibility or believability of each witness and the weight to be given to his testimony. In weighing the testimony of a witness, you should consider his relationship to the plaintiff or to a defendant, his interest, if any, in the outcome of the case, his manner of testifying, his opportunity to observe or acquire knowledge concerning the facts about which he testified, his candor, fairness, and intelligence, and the extent to which he has been supported or contradicted by other credible evidence. You may, in short, accept or reject the testimony of any witness in whole or in part. Also, the weight of the evidence is not necessarily determined by the number of witnesses testifying as to the existence or non-existence of any fact. You may find that the testimony of a smaller number of witnesses as to any fact is more credible than the testimony of a larger number of witnesses to the contrary. The burden of proof is on the plaintiff in a civil action such as this to prove every essential element of its claim by a preponderance of the evidence. All right, we will stop there, and that will conclude our literary and jury charge practice.